Enoy Extreme Media UJ. Subscribe for all updates.
And that is alien to Article 28. Actually, the proviso to Article 28, which grants the state those three elements. Article 28, that clause 2. Notwithstanding, nothing in clause 1 of this article shall be given to the court or tribunal from excluding the press or the public from all any proceedings before it for reasons of morality. That one is totally out. Public order, it is out. National security. My Lord, it will be your worship. It will be extremely out. Yes. For the state, rather for the prosecution here, we had to assert that disclosure of the identity or the face of a police officer whose warranty card is here submitted by my friend here, all his particulars disclosed, that it will be prejudicial to state security. Just one person like this. And for the record, your worship, it's not also true that Mr. Odiek Benedict is appearing before this honorable court as an IO. It's not about our government. No. If we were to read the contents of paragraph 1, this is how it's describing himself and the capacity in which he deposited his affidavit. I am a male adult detective. No, I am a male adult detective inspector of police of sound mind, attached to the Directorate of Criminal Investigations, Chibuli, and I swear this affidavit in that capacity. That is all he said. He is swearing the affidavit in the capacity of a detective inspector of police attached to the Directorate of Chibuli Criminal Investigations. It's only in paragraph 4 where he faintly brings in the issue of being part of the investigation team. That Uganda Police Force took over the investigations of the case on the 11th of February, and I was one of the officers assigned to investigate the case. One of the officers. He's not the one leading the investigations. He's one of the very many police officers at Chibuli who are investigating this matter. He didn't in any way insinuate that he is the key person, the central person, that every investigations, all the investigations hinge on him, they rotate around him. Nothing. The impression that was being created. And then paragraph says, it said, as part of the investigations, we received some items, blah, blah, blah. Your worship, I don't know whether, because if this application is granted, in essence it means the entire investigating team handling this matter will be had in common. Because each of them will claim to be under-affiliated by public attacks, because that's what we had. That they will be attacked by the public. Police officer who is supposed to move in a uniform with a name tag. Because even if he goes into camera there and we go into chambers, look what they have decided on this. He's already within this place. Even if the members of public are excluded, they remain here. We retreat to the chambers. After the proceedings, he will walk out and the cameras will be here waiting for him. Members of the public will wait for him and say, here is the man who has been in the chamber. So what does that mean? So this is why I said, Your Worship, this is a frivolous and vexatious application intended to waste time of this court. We would be doing something else now. We wouldn't be indulging in all this. So we pray that Your Worship will be pleased to dismiss it with all the content it deserves. And we proceed to the next statement.
It is again that Your Worship. My senior colleagues said a lot, but might just a few things to be covered. Because whatever they said at one point was redundant. I will start with what my senior colleagues will say, the last one. He has alluded to that authority, actual authority. Whereas it would have been a very good authority if this matter was under trial. But I would encourage how to do it. Unfortunately, the facts in the authorities decided are completely inapplicable to this matter. The authority my senior colleague cited emanates from an application that was filed and heard by the judge or the justices who were substantively hearing the matter. This is an application which relates to investigations, not the substantive trial. So the two do not speak to each other. And Your Worship, you are not bound by a precedent which is inapplicable to the matter you're handling. And we invite you to consider it redundant. It is good that our senior colleagues, especially counsel, senior counsel, appreciated the fact that Mr. Kennedy is one of the investigating officers. He ought to have withdrawn the first statement, but I think he by implication withdrew it, where he had strongly stated that he's not an investigating officer in that matter. But with seniority, we shall not So, Your Worship, Mr. Odier, Benedict is an investigating officer in this matter, and he ought to be protected by this honorable court, because this matter is not under trial. I would have agreed with my senior colleagues if this matter was being heard substantively. It is not the respondents to choose for the applicant who to be the main investigating officer. And we are not obliged to make it categorically clear in any of the affidavits that Mr. Diek is a key investigating officer. Merely mentioning that he's part of the investigative team is enough. This application is not in any way an abuse of the process. Unless my colleagues are arguing the fact that they are arguing that Article 28 clause 2 is unconstitutional. The provision is here. And a good lawyer is one who knows where to find the law. This is the law. This is not belief in Richard. This is the Constitution of the Republic of Uganda, to which this court subscribes. Your worship, doesn't matter whether the press is going to wait for Mr. Diek, unless that is a blunt thing. And this is what we are arguing. Good enough defense, counsel for our respondents, are clearly making it clear that they are looking forward to identify Mr. Diek. That is enough evidence that they are going to look for him and know who is this investigating officer. Our argument is that that alone constitutes.
Your Worship, sorry to object, but I just want to advise my colleague. Submissions of counsel are not evidence. Surely he knows that.
That's why I also remind my senior colleague that when he was attacking and mentioned William Kavicha, it was wrong, because William is appearing for the applicant.
Let's take to the substance.
Most of blood. We are here to respect the time. In fact, we are respecting the senior counsel. My senior colleagues alluded to the fact that the public by excluding the public from this application, their rights are going to be violated or prejudiced. The right to be present in court. But at the same time, my senior colleague Lukwago answered himself for the respondent that being present in court is not one of the absolute and undelegable rights. He mentioned, actually, he submitted and answered himself. Your Worship, the public's presence in court in any trial is not one of the non-delegable rights. And that's why Article 28, Clause 2 says they can be excluded from the trial. We just try, Your Worship, to paint a picture that if the Constitution suggests that the public and the press could be excluded in the substantive trial, how about this application, which is emanating, or which is intended, or which is part of the investigations? I think this is the best time for court to exclude the public and the press, because then they will have then the right to be present at the time when the substantive trial of this matter is on. A substantive trial. This is not a substantive trial. Prosecution mentioned Mr. Diek because the defense mentioned his name in the first day when he said we would like to have this Chapo Diek Benedict to be present in court on the very first day. If my senior brother
Memorize that.
And that's why we are able to speak and mention his name. Your Worship, it is not true that the respondents are addressing this court loosely. It is the defense. It is the defense. In any case, what we are here for would have been here basically for retention. Otherwise, applications for access, imaging, those are expanded. So, it is something, Your Worship, that this court can
We will not talk about the nature of the application. We interpret this. But again, if my colleague reads
it's okay, withdraw it. We can
Section
withdraw it
31
and proceed.
of the Data Protection Act, find that it is an application which is interpreted. So again, correct it.
Your Worship, it is a minor correction. Your Worship, my senior colleague Anga tried to address this court in respect to the authority that we laid upon.